Namaskar. Development of Judiciary in British India. In the India for pre-colonial times, in the Mughal era or even prior to that, including the ancient period, the judicial system as a whole neither adopted proper procedures nor had proper organization of the law courts in a regular gradation from the highest to the lowest, nor had any proper distribution of courts in proportion to the area to be served by them. Bulk of the litigation among the Hindus was decided by caste elders or village panchayats or zamindars. For Muslims, the unit of judicial administration was the Qazi, an office held by religious persons located in provincial capitals, towns and kasbas, large villages. The Rajas and Badshahs were considered as the fountainhead of justice, and the process of dispensing justice could be arbitrary. The beginning of a common law system based on recorded judicial precedents can be traced to the establishment of Mayor's Court in Madras, Bombay and Calcutta in 1726 by the East India Company. With the company's transformation from a trading company into a ruling power, new elements of judicial system replaced the existing Mughal legal system. A brief survey of those changes has been discussed below. Reforms under Warren Hastings 1772 to 1785. District Diwani Adalats were established in districts to try civil disputes. These adalats were placed under the collector and had Hindu law applicable for Hindus and the Muslim law for Muslims. The appeal from district Diwani Adalats to the Sadar Diwani Adalat, which functioned under a president and two members of the Supreme Council. District Faujdari Adalats were set up to try criminal disputes and were placed under an Indian officer assisted by Qazis and Muftis. These adalats also were under the general supervision of the collector. Muslim law was administered in Faujdari Adalats. The approval for capital punishment and for acquisition of property led to the Sadar Nizamat Adalat at Murshidabad, which was headed by a deputy Nizam, an Indian Muslim, assisted by the Chief Qazi and Chief Mufti. Under the Regulating Act of 1773, a Supreme Court was established at Calcutta, which was competent to try all British subjects within Calcutta and the subordinate factories, including Indians and Europeans. It had original and appellate jurisdictions. Often the jurisdiction of the Supreme Court clashed with that of the other courts. Reforms under Cornwallis 1786 to 1793. Separation of powers. The district Faujdari courts were abolished and instead circuit courts were established in Calcutta, Dhaka, Murshidabad and Patna. These circuit courts had European judges and were to act as courts of appeal for both civil and criminal cases. The Sadar Nizamat Adalat was shifted to Calcutta and was put under the Governor General and members of the Supreme Council, assisted by the Chief Qazi and the Chief Mufti. The District Diwani Adalat was now designated as the district seat or the Jilla Court and placed under a district judge. The collector was now responsible only for the revenue administration with no magisterial functions. A gradation of civil courts was established for both Hindu and Muslim laws. 1. Munsif's court under Indian officers. 2. Registrar's court under a European judge. 3. District court under the district judge. 4. District courts as provincial courts of appeal. 5. Sadar Diwani Adalat at Calcutta and 6. King in Council for appeals of £5,000 and above. The Cornwallis Code was laid out. There was a separation of revenue and justice administration. European subjects were also brought under jurisdiction. Government officials were answerable to the civil courts for actions done in their official capacity. The principle of sovereignty of law was established. Reforms under William Bentinck 1828 to 1833. The four circuit courts were abolished and their functions transferred to collectors under the supervision of the Commissioner of Revenue and Circuit. Sadar Diwani Adalat and Sadar Nizamat Adalat were set up at Allahabad for the convenience of the people of upper provinces. Till now, Persian was the official language in courts. Now the suitor had the option to use Persian or a vernacular language, while in the Supreme Court, English language replaced Persian. 1833, a law commission was set up under Macaulay for codification of Indian laws. As a result, a Civil Procedure Code 1859, an Indian Penal Code 1860, and a Criminal Procedure Code 1861 were prepared. Later developments 1860. It was provided that the Europeans can claim no special privileges except in criminal cases, and no judge of an Indian origin could try them. 1865, the Supreme Court and the Southern Adalats were merged into three high courts at Calcutta, Bombay, and Madras. 1935, the Government of India Act provided for a federal court set up in 1937, which could settle disputes between governments and could hear limited appeals from the high courts. Evaluation: positive aspects of judiciary under the British. The rule of law was established. The codified law replaced the religious and personal laws of the rulers. Even European subjects were brought under the jurisdiction, although in criminal cases they could be tried by European judges only. Government servants were made answerable to the civil courts. The negative aspects: the judicial system became more and more complicated and expensive. The rich could manipulate the system. There was ample scope for false evidence, deceit, and chicanery. Dragged out litigation meant delayed justice. Courts became overburdened as litigation increased. Often the European judges were not familiar with the Indian usages and traditions. Dhanyavad. Thank you so much.